The law matters. Of course it does. Welcome once again. I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with the law matters. A better understanding of the law puts you in a better place to decide how to protect yourself, your family, and your business. And as always, we say there are times when you may want to decide to handle some issues yourself. If you do decide to enlist professional counsel, our goal is to help you be better prepared, and so will the outside counsel you select. Our goal always is to help you to achieve the best possible results while saving time and money. Again, we want to welcome and thank Attorney David Bazar from the Bazar & Associates law firm in East Providence for joining us and weighing in on the various topics that we cover. Today we're going to talk about estate planning, which we've done before, but how to avoid the issues that can cause some serious problems. What have you overlooked? What might you need to take a closer look about? What might need more specific language? There are certain key areas that seem to crop up as things that people frequently overlook. As we review some of these on the list, perhaps it'll trigger in your mind something else that you need to consider or maybe reconsider. And most importantly, we hope to help you avoid the possibility of having something contested. So David, a will, an estate plan, things need to be very specific in their language, and yet, depending on someone's circumstances, how do you possibly anticipate as many contingencies as there possibly could be? Why don't you set this up for us, and before we get into the details of some specific problems, how does a trust work, and how does the instrument work?
When you talk about estate planning, oftentimes, from a lawyer's perspective, we're talking about two different types of plans that include many of the same issues that need to be covered. So there's a will-based plan or a trust-based plan. However, it's not just whether or not you have a will or have a trust, which is very helpful, but it's just one part of the plan. So when somebody comes in to talk about what they want to do, what we always ask them is, well, what are your goals? What are your concerns? What are you trying to accomplish? And then we'll talk about the family and the property and all of the other issues that go into the plan and develop the successful plan that will best fit what they need for an estate plan, which includes disability planning. While you're alive but you become disabled, who's going to be the person to make decisions for you, both financial and medical, and what happens if you die.
And there are different plans. Some are revocable trusts, some are irrevocable trusts. When we've done the estate planning topic in the past, we've mentioned that some things are available to people online. Sounds so simple, sounds so easy, and yet also has so many holes. And theoretically, talking to a lawyer is helpful because you can go through some of the various scenarios that most people wouldn't have a reason to think about. What do we say? Sometimes that people fail to plan to fail. You want them not to avoid things that they should consider for the long term.
So when you go to an attorney who practices in the area of estate planning, you're not going there to buy documents. You want to buy documents, you can go online and buy your documents. What you're going there for is advice and counsel. And the attorney needs to listen to your story, understand what your needs are, what your concerns are, what your family dynamics are, what your property is, and then, based upon all that information, discuss with you options to carry out what it is that you would like to accomplish. So you mentioned a myriad of types of documents: revocable trust, irrevocable trust, wills, power of attorneys, healthcare power of attorneys. Those are all documents that can be designed to carry out the wishes that you may have, but it's understanding what it is that you're trying to accomplish first before those documents can be even recommended and then drafted.
So as I looked at the list of things that people often forget about, even once they've done this, say you've helped someone prepare, or suppose someone's done something on their own, well, people forget that they need to revisit these plans because things change. So if you are speaking to a client, what would be the things that you would tell them that would trigger a time that they might need to reconsider and review the plan?
So we often tell clients that depending on the type of document you've drafted and the type of plan you put in place, usually it's a will or a revocable trust, that can be changed at any time. And if there's a change in your family or family dynamics, the people that you would choose to be in place to help carry out the plan for you, that's one of the things you need. That would be a trigger to go back and revisit your plan. The property that you have, the money, the real estate, whatever it is that you've acquired, if that's changed one way or another, would be another reason to revisit the plan. And I often say, and come back every 5 years or so, because there could be a change in the law, or there could be some other changes in your situation that you really haven't thought about that you might want to discuss. So time, lapse of time, 5 years, I like to use. And I use 5 years because oftentimes people will come in and they'll say, I want my mom or my dad to have a role in this plan that we're putting together. But they're in their 70s and they're good now, but I don't know. So should I pick someone else? And I'll often say, pick the person you want now. If you think they're good now and they're probably going to be good in 5 years, pick them. And let's look at it again and see how they're doing and what the situation is 5 years from now.
So in tandem with what you're saying relative to that, one of the issues that is listed in common oversights is that people often will just and only name one beneficiary, and they should not, because things change. Someone may pass away, you have to update it. If you have a trust, maybe it's easier. If you had two, you wouldn't necessarily have to go back to someone. How do you feel about that, David? What's your guidance on that?
When we're drafting a plan, even what doesn't matter whether it's a will plan or a trust plan, we'll often have multiple contingencies. Multiple contingencies in a trust for who the backup trustees would be, for disability, death, trustees for a trust that may be created by the trust, separate trust, lifetime discretionary trust that you may set up for your children. So there usually is multiple backups to whoever you select first. And then beneficiaries, usually multiple backups. And oftentimes it's your children and then their children or your grandchildren. So that would be a plan that we would call descendants per stirpes. Per stirpes is a word where you're saying my children's children will step into their shoes, if your grandchildren, if something happened to them. And oftentimes that's as far as many people will go, but we think you need to go even further than that. And we often in both wills and trusts will document, have a section in the document on remote contingent beneficiaries. It's called remote contingent beneficiaries because the likelihood of it happening is remote. It's contingent upon everybody who's already selected not being there, being gone. And so who are the beneficiaries going to be? Oftentimes that's the most difficult thing for people to think about and consider and do, but it's important because if you, one of the attorneys I used to work with used to call it the nuclear war provision. Everybody that you had selected for beneficiaries are wiped out. I call it you're on the family trip and you're all on the same plane and you get lost in the Bermuda Triangle. You're going, we don't know where you are. Who is going to be the beneficiary? Sometimes we consider other family members, more remote relatives, or charities.
We'll get to that one in a minute. This one surprised me. One of the common oversights is listed as not discussing with family and friends your will or your trust. Now, I'm sure you hear all the time, I hear, people hesitate to discuss the contents, well, never mind the contents of their will or their trust, what they have at all for assets. Kids are often salivating to know what they're going to get. What's your position when you speak to clients about whether or not they should and what they should say to as they refer to, family and friends. Perhaps friends are in the will and perhaps they have to do something as executors, whatever. What's your feeling about that? What's your thought?
So we feel that transparency is usually the best policy so that there isn't a contest or an issue that's raised after you're gone. And oftentimes we'll have clients who will ask, can I bring my children in so you can explain the plan and how it works to them? And that's part of what we do. So absolutely. Now, sometimes they don't want a specific discussion of what the assets are or what the value is. They may want an overall picture, the 10,000-foot view of what it is that is going to happen and who is going to play what role and why. Sometimes they do want to be more specific, but whatever it is that they want to do, we do encourage that. You don't have to tell them you're going to get this amount of money or that amount of money if you feel there's a reason not to, but you should be honest and open about who's going to get what and why if you're not treating everybody the same. And sometimes clients don't even want to do that, so we have to respect that.
Interestingly, on one side of the ledger, there is a thought that one reason you may not want to have a trust or a will at all is because it often causes disharmony when someone knows before you pass, and even more, not that it would bother you once you're gone, but you have disharmony after you pass because someone feels slighted or whatever that is. So as an attorney who's working with a client, is it your responsibility or you just take the initiative to try to explain that if your client says, I know we're going to have some issues here, David?
We try to, we try to address those issues up front. And I think it's important that you get that out there so that your client deals with it in such a way that it doesn't become a problem down the road. So if it's a matter of writing it out in the trust or the will so it's explained later and not right away, that's a way to do it. But there's a much better way of dealing with these things with transparency than trying to hide them or not deal with them. Oftentimes when someone is left out of a trust or a will, we'll write out, they've been provided for during our lifetime or they've got their own assets, and sometimes the least equitable thing to do is to treat everybody equally. It's sometimes better not to, but explain why you're doing that.
Do you, when you are told that there may be some issues that are going to be raised among the family members, not all agreeing, do you suggest to your clients that, you could write into the will or the trust, anybody who challenges this suddenly is routed out?
We do that all the time. It's actually a standard clause in both our wills and our trusts, which say that if anyone contests the will or the trust, they're out. And we've had to use it. We had a case where a dad who had lost his wife was being taken care of by one of the children, and the other child had very little, if at all, to do anything with them. He left the bulk of the estate to the son, who was taking care of him, left less to the daughter, but did leave her something substantial. And when her lawyer contacted us and said she wants to contest this, I said, please take a look at this section and then let me know if she really wants to do that or not.
And yet there are times when trust can be challenged, wills can be challenged. How do you safeguard against that? Obviously, as I opened the segment, I understand you need to be as specific as you can be, but there are so many circumstances and variations that could cause someone to say, but that wasn't the case. And how do you deal with that?
So a well-drafted document, a well-drafted trust is difficult to challenge. A well-drafted will is difficult to challenge. So what you do is when you're drafting it, if you have a concern about something, you make sure that you're specific to deal with whatever that issue might be.
Yes.
If it's a challenge that might come to capacity, the capacity to sign a will or a trust.
I was just going to go there.
We will get documentation from a doctor or somebody that says whether or not the person had capacity, obviously that they do have capacity and that they've been seen. And if it's a situation where we're very concerned about it, we'll ask for multiple letters. We've done that in the past.
And so if that is kept with the documents, that sort of circumvents the likelihood of someone wanting to challenge it. But what if the circumstances change and the children who would be affected say, well, they didn't know, they didn't change it, but my circumstance changed, they would have wanted. Is that are those grounds for someone to challenge?
No, if the person had capacity all the way through and there was no issue with that, and they didn't take the steps to change their documents, then it's not really going to be an issue that, well, they didn't know that I now have this need or that need. Usually that's not a factor in determining whether or not the documents that are being either entered into probate or using as the trust vehicle to distribute the assets are going to be subject to a challenge or not.
Okay, and two things. One was you mentioned charities. Do you bring that up when someone's sitting before you, or do you wait to hear first? Well, I'm sure you wait to hear first whether or not they have a favorite charity or four. If they don't, are you likely to bring up, well, after this one, that one, and this one have been considered and placed in the trust or the will or whatever, have you considered charities? Would you interject that, or would you just let that ride?
The meeting with the client is a discussion. And the client usually will be the one to drive the discussion in terms of what they want and how they want things done. As they are doing that, if I feel that there's a point where they've left something out or haven't considered something, I'll raise it. So when we talked about the remote contingent beneficiary, for example, most people don't think about that. So now it has to be raised as, all right, well, all these people you've mentioned aren't going to be here. If they mention charity, obviously that's going to be further discussed. In the idea of maybe they want to leave a specific amount to the charity now, regardless of what happens to everyone else. But what if there is nobody else? Do they want that charity or other charities or some people in charities? It can be any combination of what they want to be the beneficiary of those that they expected to be there aren't going to be there. So we won't ever suggest, well, how about this charity or that charity? But we'll suggest the idea, have you considered charities?
When you're having this discussion and fleshing these details out with a client, do you record it? How do you get to document or make sure, well, obviously they're going to review to see that it's accurate, as many contingencies and circumstances that you can possibly anticipate?
We don't record the meetings. I'm not even sure if that's something you'd want to do because of attorney-client privilege and all of that.
And I wanted to have a chance to address that.
And so one of the things you were talking about was challenging things. So sometimes people will challenge things based on undue influence. One child brought the parent in, not two or three or however many there might be. So what we do in that instance, just to go back to that, is we'll ask the child to leave the room, or whoever brought the person in not to stay in the room, not even to come into the room, so we can have a discussion with the client or clients alone, so that we can, and we do it as a practice. So if it ever came up, that no one else was in the room when the discussions of how we wanted to leave things were had. It was based on just me and my client, no other influence. And if I have a concern about it, I'll actually delve into that a bit. And sometimes we will, at that point in time, have a paralegal come in as well to have a discussion and document both the fact that we had the discussion and what was discussed.
So let's assume it's a child that comes in with the parent. The parent's the older. You're going to be working on their will or their trust. Address, if you will, how you handle what a parent who's making this will or trust, how they are planning for their children. I was reading that there are times that the father thought it would be just swell to give their son their season's tickets to, I don't know, football, a sporting event or whatever. Do you guide and counsel people in some way to talk with the child? Who knows, maybe they're not sports fans, or maybe there's stock and the child may not have the capacity, certainly at 8, to handle it, maybe at 28 or whatever. How do you go through that when you're trying to pace out addressing the situation as it is and anticipating how you're going to deal with this in the short term and the longer term?
So you always start with an explanation or a discussion from the client as who the people in the family are, who has, I like to know background. How old are your children? What do they do? If they're older, do they work? Are they married? Do they have their own children? Are they good with money? Are they not good with money? Are they good with medical decisions? Not good with, so that not only do we know when we start planning on who's going to get what and how they're going to get it, because they could get it outright, it could be held in trust for them. They may need help managing money with another trustee for them. We want to know all those things, but we also want to know who can help my client when they get older with financial things and medical things. So we want to get as much information about the people as we can so we can then give advice on how the plan should be put together.
Makes sense. Of the issues that you would broach, you mentioned health care, and do you also mention how someone would plan for the final arrangements, their actual death? Is that part of what you would use or you would discuss in a session?
Yeah, we do. And oftentimes what we'll do is when we create a healthcare proxy or a healthcare power of attorney, there's a place to put in special instructions. And oftentimes the clients will tell us whether they're an organ donor or not an organ donor. We'll put that in. Oftentimes they'll say whether they want to be cremated or buried or where they want to be buried. We'll put that in. So what we often encourage people to do is put it in the healthcare proxy so it's written somewhere. So if your healthcare agent is making decisions in the hospital for you, they know by looking at the document what it is that you would want. We also encourage people at certain times in their lives to make arrangements. And we give a binder with all of the documents in it to our clients so they have their plan in one place with all the documents. We encourage them to put in any funeral arrangements they may have had or any other information that would be relevant for whoever's going to pick up that binder and deal with it, including assets at that point in time. So there's a good list of where to begin in determining what the assets are.
Speaking of assets, and considering this age, a very big issue becomes dealing with digital assets. Forgetting about dealing with digital assets. Do you bring it up? How do you handle it? Many people don't maintain updated records. Many don't always know their passwords. Many are very reluctant to have anyone have access to them. How do you handle that? Or well, I'm sure there are many ways that it can be handled. How do you approach it?
So again, we have that binder with all the documents in it. Our recommendation is you don't give that binder to anybody until they need it. Of course, it would be important for them, whoever it is that would need it, to be able to get it. We don't want it locked up. Oftentimes in the old days, people would lock their will or their power of attorney in a safe deposit box.
Yes.
And they were the only ones who could get into it. So it really created problems because if they passed and couldn't get into the box, neither could the executor because you couldn't get the will to get them appointed to be the executor. So it created a multi-layer issue. With digital assets, we actually do put in powers of attorney and wills and trusts and other documents, the ability for the trustee or the executor or the agent in the power of attorney to deal with digital assets so that if they need to cancel Facebook or LinkedIn or whatever else it might be, they have the authority to do that.
And there's online banking, there are email accounts. People change their passwords frequently. How do you possibly maintain accurate records about that? It's
difficult. You ask your clients to, again, keep whatever those login and password lists are in that booklet so that someone could get at it if they needed to. But oftentimes, if it's a bank account or whatever, those usually or may get frozen anyway, so you couldn't get in. So you're going to have to take the paperwork into the bank to deal with it directly.
So many financial planners have client portals. I imagine many lawyers have those too. If it were a digital portal and someone were the executor, they could have access to that portal, which might have an easier way of maintaining the most updated passwords as long as the person did that to keep it updated.
Yeah. So
that's a lot of ifs.
It's a lot of ifs. It's a lot of online stuff with sensitive information.
Yes.
I'm more of if you got your booklet, your binder, your notes, and you have it locked up and no one can get at it, I'd rather have it there.
Sounds right. So we talk about some of the things that you should put in you have to fund the trust, never mind we should probably, what does that mean, David? You should probably address that now.
So when you create a trust, obviously the purpose oftentimes is to make it easier to pass assets to whoever's going to get them after you're gone or to manage them. And in order for that to happen, you have to put certain assets into the trust. Otherwise, you might have to still probate a will with a pour-over aspect to it so that it goes into the trust. But the idea is if the trust owns the assets, then the trust nothing goes through probate that's in the trust because it's not in your individual name. Only assets in your individual name are subject to probate. So oftentimes we'll put in bank accounts, we'll put in investment accounts, we'll put in real estate. What you don't put into a trust is retirement accounts, because that would be like cashing them in. You're changing the ownership of them. You can't do that, but you name either the spouse, if there is one, or somebody, or the trust is the beneficiary.
Can you tell me what happens in a situation where many people have joint accounts, their spouse, and then they pass away? How do you address whether it's supposed to be that spouse gets it because it's joint, but that may not be what is consistent with what a trust or a will would say in terms of how much each named person should get? How do you deal with that? Is it a matter of just cautioning someone about the impact of having joint accounts, or how do you deal with that?
When we create a plan, we will discuss how things are titled, especially if it's a trust plan. And there are things you need to know. If real estate's owned jointly with right of survivorship, no matter what it says in your will or your trust, if that's how it's owned, that's how it's going to pass. If you have a bank account that's joint with right of survivorship, even if your will says something different, that doesn't control where that asset's going to go because it's titled in a joint name. If you have life insurance with a beneficiary named, but different instructions in your trust or your will, the life insurance contract, the insurance company is going to follow the contract and pay whoever's listed as beneficiary. So as part of your plan to do this correctly, you need to look at how things are owned, how they're titled, and who the beneficiaries are.
Thank you. I had one other quick question, but laws change relative to taxes. That may happen before someone comes in to visit with you again to change it. Is the onus on you to tell a client that tax laws have changed, you might want to come in and revisit this? Is that the client's responsibility or your responsibility?
So oftentimes a document will be drafted with an eye towards taking into consideration potential changes, not always, but if there's a major change, it's really, the lawyer's not going to be able to reach out to every client, although if there was something that was so important, we might send out a mass mailing, but it's not going to necessarily get there, so we always tell the clients to keep their eyes open and contact us.
Good to know. We hope that this information has been helpful to you. As we say, please continue to stay tuned to The Law Matters. It matters to you. Thank you for tuning in.